Start. The appellant in writ proceedings sought quashing of an order dated 2 April 2012 passed by the second respondent cancelling her appointment as a junior clerk. Full stop. The second respondent held that the appellant had gained employment on the basis of a forged caste certificate and that consequently and in light of clause 12 of the appointment order, have selection and appointment was liable to be terminated. Full stop. Unsuccessful in her challenge to the said order before the learned single judge, the instant appeal has come to be preferred. Full stop. The learned single judge, while dismissing the writ petition on 4 February 2016, has noted that the caste certificate on the strength of which appellant obtained appointment was found to have been never issued. Full stop. It was further noted that while the appellant claimed to be belonged to the Turaha caste, in the inquiry proceedings, it was found that her father held a caste certificate which showed him as belonging to the Dhimar caste. Full stop. The learned single judge repelled the contention urged on behalf of the appellant that her appointment could not have been cancelled after more than 5 years without holding of the departmental inquiry on the ground that the cancellation of the appointment was not on account of any misconduct but in terms of clause 12 of the appointment order, which itself empowered the appointing authority to annul the appointment in case it was found that any of the certificates submitted at the time of gaining employment for were forged or fabricated. Full stop. Para. We find ourselves unable to accept either of the two submissions. Full stop. At the outset, it may be noted that when an internal inquiry was instituted, a report was called or from the Tehsildar Kasganj in respect of the caste certificate submitted by the appellant. Full stop. The report of the Tehsildar, Kasganj dated 14 December 2011 stated in unequivocal terms that no such certificate had been issued in favor of the appellant, nor was there any record or any evidence of the issuance of the caste certificate to her by the office of the Tehsildar, Kasganj. Full stop. Additionally, it was found that the caste certificate of the father of the appellant recorded him as belonging to the Dhimar caste, while the certificate submitted by the appellant showed her as belonging to the Turaha caste. Full stop. It was on the above state of record that the second respondent proceeded to cancel the appointment of the appellant. Full stop. As the facts noted above would establish, it was not the allegation of the respondents that the appellant had either wrongly been granted a scheduled caste certificate or that she did not belong to Turaha caste. Full stop. These issues may have merited a reference to the District Scrutiny Committee. Full stop. However, the respondents were faced with a case where the caste certificate was found to be a forgery, and as per the report of the Tehsildar, Kasganj, the said certificate having never been issued by his office. Full stop. As such, we had no merit in the submission that the dispute was liable to be referred to the District Scrutiny Committee. Full stop. Para. Mr. Rakesh Sinha, learned counsel appearing for the appellant, submitted that this court has held that the beneficial provisions of the Act are to be applied only for the purpose of interpretation of the act and not for arriving at a conclusion whether a person is juvenile or not, and the question whether an offender was juvenile on the date of commission of the offense or not, comma, is essentially a question of fact, comma, which is required to be determined on the basis of the materials brought on record by the parties, full stop. He submitted that this court has further held that Section 35 of the Evidence Act, comma, which provides that an entry in a register maintained in the ordinary course of business by a public servant in discharge of his official duty or by any other person in performance of a duty specially enjoined by the law of the country, comma, will only apply if the conditions mentioned in Section 35 are fulfilled, full stop, para. He further submitted that Section 35 of the Evidence Act could not be applied to the entry of date of birth of respondent number 1 in the school records produced on behalf of respondent number 1 before the trial court and on the evidence as produced, comma, the trial court rightly held that the date of birth of the respondent number 1 cannot be believed to be 5.10.1988, full stop. He submitted that the trial court, after scrutinizing the evidence, has held that the evidence produced by respondent number 1 have been created for escaping conviction for a grave offense such as murder and was not believable, and by physical appearance respondent number 1 looks to be over 18 years of age, and on 11.7.2004 he was an adult and not a juvenile, full stop. He submitted that this finding of the trial court on a question of fact with regard to the age of respondent number 1 could not be disturbed by the High Court, full stop, over.